May I please, my lord? My lord, I beg to mention an pending matter, criminal petition. The parties have arrived to a settlement through Supreme Court Mediation Center. So it may be listed for tomorrow.
It's a
It was
criminal.
last listed in the month of May.
A criminal.
My lord,
It's a, what is that?
quashing of FIR, criminal petition, pending
Pending.
for tomorrow. They've settled the
Tomorrow.
matter.
Tomorrow list. Day after tomorrow?
That will be Saturday,
Oh, day after tomorrow is Saturday. Okay. Monday then?
Monday.
Okay. I beg to mention criminal revision, criminal petition number 30/2025. As per the court
Which
order.
item?
No, item is no. Item is
Signature was, they were missing their signature, so yes, that was fixed on 13th, but
17. But the petitioner number 2 is leaving for Kolkata on 16. So matter may be taken up tomorrow.
it was fixed. yes. Where, 13th? When fixed? Fixed for 16. Yes, but Now you want to prepone it.
Yes, for tomorrow.
When? Tomorrow, Monday.
No, month
tomorrow.
16 early on.
What is this matter about?
Actually, my lord, this the petitioner's number 2 is leaving for Kolkata on early in the morning on
No,
Monday.
what is this matter about? The case is.
Quashing
Quashing
petition, joint petition.
Okay, why it was fixed on 16th?
To verify the signature of the.
Okay, okay, no problem.
Tomorrow?
Yes.
Yes.
Okay.
Obliged.
May I, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 19 on behalf of K. Tama, Your Lordship. Due to some personal difficulties, he's not available today, Your Lordship. So,
You are
matter
for?
mention. On behalf of K. Tama, representing respondent,
Okay, so who is for the, have you informed the?
I have already informed, yes.
Who is for the petitioner? Okay. Who filed, state file? Okay, Mr. You are Mr.
Jay Sri. On behalf of K. Tama.
Okay, yes. Land Council. Submitted the Land Council for the respondent, Mr. Ketama. Mr. Ketama, Land Council for the respondent has some personal difficulties today, and therefore prays for adjournment, to which the Land Council for the appellant has no objection. Accordingly, the prayer is allowed. List this matter after
3 weeks, Your Lordship.
3 weeks. Okay.
May I, Your Lordship? Your Lordship, I beg to mention item number 17 and 18. I'm here for the respondent. The conducting counsel for this matter.
Why this matter, huh?
Your Lordship,
When do you want, you said?
conducting counsel for this matter is out of the station, this K. Roland. So matter may be listed after.
Counsel
2
for the
weeks.
respondent?
Yes, Your Lordship.
Who is for the then appellant? Have you informed?
Yes, Your Lordship.
Make the appeal. Miss,
M. Sora. Sora.
submitted the council, the conducting council is out of the station, therefore pray for adjournment. She has also obtained consent from the land council of the appellant. When pray for, when do you want to say?
After 2 weeks.
Yes, pray for come and this matter after 2 weeks.
Obliged.
May I please?
Yes,
My lord, here challenging the order dated 01/05/2025 passed by the learned court NDPS UPA. As per this order, the seizure of contravenes totaling the seized contravene was 6.43 grams out of the 2 accused person. The present applicant only had the 5 vials, and the co-accused person 46 vials, all together 51 vials, and excluding the weight of the vials.
See, the substances recovered conjointly constitute the commercial, it appears.
My lord, that is
And that is the charge frame.
Yes, that is the interpret, that is the charge of the planet court below.
Not
But
commercial.
here,
Intermediate.
yes,
The
interpret,
charge frame under
21B.
21B. And I prayed for charge maybe frame under 21A because it's fall within the small quantity.
No, this is
As per the
probably-
seizure memo.
It's not trying to separate that one. So the charge can be altered at any stage after the evidence. When it comes, that no, the possession, the recovered substance from you is only a small quantity, and then you are liable only to be punished under A only. This charge can be altered. There's a provision, 216, I think.
That is,
CRPC
my lord, that
amendment.
is there. However, rights of the applicant, how right of the accused person is being curtailed because 61A of the NDPS, there is a provision for getting immunity. Because this, the 61, 64A of NDPS Act is getting immunity from the prosecution because this present applicant is a drug addicted person. Only 5 vials were recovered from the present
Now,
applicant.
see, he is fine.
As part of
Another
FIR, my lord,
where is the impugn order? Let us
yes,
just-
At page number 44.
page number 44. And my lord, before going to this impugn order, I would like to take the draw of this present FIR and charge sheet where clearly reflect that the only 5 vials has been recovered from the present accused person.
You have annexed the charge sheet also?
Yes.
Where?
Page number 14 onward. This is charge sheet
14.
14, 1 crore. And page number 17 is the relevant para, the brief of the case.
No, where is the seizure list? Have you annexed?
Yes,
It's
seizure
seizure is-
within the, within the charge sheet seizure.
Page
is
number
there.
23 is the scissor memo, Your Lordship.
This is from,
Page number
what is the
17.
name
charge-
of the present accused?
The name of the present accused is Koda Rikam.
For the RICAM,
Yes.
vial suspect, 51.51. For what? This is 51,
That is,
51.
no, that is serial number 1, 51 vials of suspected contraband, Your Lordship. That is serial number 1.
Weighing 6.43 grams, excluding the weight of vial. So this 51 vial is,
This is
this comes
total.
under,
It is 51 vials, Your Lordship. All the vials excluding the container, when separately weighted the contrabands, it amounted to 6.43, which is the intermediate.
okay. This comes under intermediate.
Yes, Your Lordship.
But
Then-
this was not
then-
segregated. This was not segregated. As per the record, section 50 of NDPS has been maintained. That
Just a
means
minute.
personal check.
51 vials of suspected contraband substance, so weighing, excluding that. It's excluding the
Yes.
weight of vials.
My lord, it will
What
better.
was not segregated, you said?
This 6.43 is an actual contraband found inside the vials, 51 vials. And within the 51 vials, only 5 vials has been recovered from the present accused person. So this is not segregated. So as per, if we go through the charge sheet, it
Where,
will
where do we find
details.
that? Where do we find that? Only 5 vials were recovered from the present accused?
Yes,
Where do we find
this FIR, charge sheet and police communication, OC to SP. That communication, it is detail has been given.
Where?
Yes, let me read the FIR first. This is page number 43. To the officer in charge, New Delhi Police Station, Papumpara, Arunachal Pradesh, subject Past information report. Respected sir, with due respect and humble submission, I would like to state that on 25/4/2024 at around 21 hours, a relevant sources provided information that two people who are chain peddler who are engaged in consumption and selling of the drugs at New Delhi area, Papumpare, Arunachal Pradesh for past many years and working together. He revealed their identity to a Sri Bengya Kaya and Sri Kodarikam, and also that currently will found near Bagetinali, New Delhi together since they work in purchase, selling, and consumption of drug peddler. The same was intimated to SDPO Nahalagan and ESC Nahalagan. Accordingly, police team led by SIV Lengi along with ready party left to the said place and traced both Sri Bengya Kaya and Sri Kodarikam. They were intercepted after being served under Section 50 NDPS Act. After self-search, personal search was conducted over the body of the suspected drugs peddlers, identified as Sri Vengya Kaya, 20 years, son of so-and-so, 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 and Sri Kodarikam, age so-and-so, 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 and recovered 46 vials of suspected drugs, under bracket heroin, from a black bag held by Sri Vengya Kaya, and also recovered 5 vials of suspected heroin, under bracket drugs under bracket heroin from a bag held by Sri Bengyarikam. Only 5 vials has been recovered. The total weight of suspected drugs is 6.46 grams, excluding weight of 51 vials, excluding weight of vials. This is the FIR, my lord. And the same thing has been communicated to the OCPS New Delhi to the SP. And this has been already reflected in the charge sheet also. Only 5 vials has been recovered from the present accused person. So if we segregate,
Yes.
Yes, your lordship will see that his main contention is that he had only 5 vials of contraband and the other person has 46, your lordship. Now, if your lordship will see the FIR, that body search was made. If there was a search on the body.
Section 50 is given.
yes.
Section 50 is given.
Then
After complete.
50, in section 50, your personal body is searched, your lordship. From the body, if 5 vials was seized from him, that would amount to his personal seizure, your lordship.
Yes.
But your lordship will see this was a joint possession, your lordship. More particularly in the FIR, therefore, it was very specifically mentioned that 46 vials suspected heroin from a black belt held by Bengyar. It does not discloses that it was of Bengyar. It only speaks of it was held because they were together consuming and in the verge of selling the contraband, your lordship, where in the police.
Bag held by each
Yes,
one of them.
it was just held. If it
Okay,
if
in the
it
same,
was a
in the
case of
same vehicle.
yes,
Okay.
if it was a case of bodily search and it was any vials were and any contraband was filed from the search during the body search, your lordship, that would amount to whatever he is submitting, your lordship.
This was for the purpose of selling it.
Yes, and also your lordship will say this is a joint possession, and therefore in the seizure list, if your lordship will then come back to page number 23, the seizure is not made differently. Body search was done of an individual, both the individuals, your lordship. No contraband was found in the body search.
Body search not found.
Yes, from the bag it does not speak that that bag was particularly of his.
Hmm.
The property was of his, your lordship. It only states, the FIR said that it was held by that person because they were in the verge of running, your lordship. So there was a joint possession and therefore even the seizure memo speaks of the joint possession of the contraband.
Yes, it is not from his body search only. It was from the joint possession.
Yes.
And
my
that is
lord.
why in the seizure memo, they have said that the total of 6.43. Now later on, if he clarified that, or the witness clarified, or the person who sees clarify that it was from the possession, then different case. But unless that is done, it appears that if it is from the same vehicle and then it's a joint possession only, and that is why prima facie it appears that the total is 6.43,
Absolutely.
not individual, not from your body, from your body, huh? Not recovered out of body search.
My lord, I'm not agreeing with the submission by the learned PP because here section 50 NDPS is applied. when section 50 NDPS
You're
applied, it is
you're
personal
agree- you
search,
agree or not
personal
agree,
body
that
search.
Doesn't comes.
My lord, after personal body search,
Hmm.
only 5 vials has been
No,
found
No,
from the
no,
my
sir,
petition.
Nothing was found, it appears.
Not from the body search, but
Not
from the bag.
Not from the body, you see.
My lord, section
After search,
50.
personal search, after self-search, personal search was conducted over the body of the suspected drug peddlers, so and so, so and so. Drug peddlers, so and so. And Mr. So and so, and recover from the bags only,
Yes.
from the bags.
Bag does not comes into body search, Your Lordship. Body search does not come.
This bag is
Bag-
not from
bag
mine.
possessed by
This
others.
this bag belong to the co-accused person.
That has to be proved, Your Lordship, in the trial.
Yes, age, but this is a FIR. The case is only generated from the only FIR. The FIR clearly indicate that this bag belongs to some one person.
Where, can you just see once in the chart sheet to clarify this, whether they have separated?
Page number 17, this is a brief of the case in the charge sheet. Here clearly indicating, my lord, only 5 vials has been recovered.
Where is the chart sheet?
Yes, page number 70 is the brief fact of the case.
17.
17. The prosecution story of the case is that on 25/4/2024 at 21 hours, a written FIR received from SI Vivek Lengi of New Jersey Police Station against Sri Bengya Kaya and Sri Koda Rikam to effect that mention both chain peddler who are engaged in consumption and selling of drugs at New Jersey area, Papumpare, as information received from our reliable sources. Accordingly, a police team led by SIV Lingi along with ready party left to the said place and traced both accused, both Sri Bengya Kaya and Sri Koda Rikam. They were intercepted after being served notice under section 50 of NDPS Act. After self-search, personal search was conducted over the body of the suspected drug peddler, identified as Sri Bengya Kaya, 20 years, son of Bengya Tagum, Kauchi, Koloriang, Korongkome, Arunachal Pradesh, and Sri Koda Rikam, 23 years, son of Koda Hale did village towards Arunachal Pradesh, and recovered 46 vials of suspected drugs from a bag held by Sri Bengya Kaya. He clearly mentioned, my lord, held by Sri Bengya Kaya, the co-accused person, and also recovered 5 vials of suspected drugs, heroin from a bag held by Sri Bengya Rikam. Here 2 bags, clearly mentioned in the charge sheet, 2 bags. One bag is held by from the co-accused person containing 46 vials and 5 vials held by me containing 5 vials only. Here clearly segregated the contraband seized from the both accused person. My lord, my humble submission is that this present appellant is a drug addicted person.
They have been purchasing and come to the next page.
The continuation, the total weight of suspected heroines is 6.46 gram, excluding weight of vials.
Furthermore, both arrested.
Yes.
So whether records need to be called for?
No, Your Lordship.
Not required.
Not required. Even
Have
at
to
this
decide.
stage, Your Lordship can decide on this matter, Your Lordship.
Hmm?
I have a
Yeah,
citation of even the Supreme Court.
Let us see the impugn order, what it justifies.
44. And then during the time of
Since traveling together, possessing in the vehicle, not from their pocket or body. And I think
my lord,
both are liable,
as per
equally
the
liable.
provision, my lord, as
If
per
it is
the
for the business purpose, if it is only for the consumption purpose, if you say that you're
gram each fall within the medium and is for commercial and above that is completely for commercial and below 2.5 gram is for self consumption purpose. And here I have annexed my medical detox medical prescription in my application. Here clearly shows that the present accused person was addicted person and it was the contraband was found with the accused person only meant for self
now see
consumption purpose.
the learned trial court has come into conclusion that since they were apprehended together, traveling in the same together, you can separate at the time of evidence only. But then how do we just appreciate the evidence now at this stage? It's prima facie. You see, prima facie, it appears that they would since they were traveling together, it was recovered from the bag
My
and
lord,
then totally so.
the charge supposed to be
So at
framed,
the
but
time of
based
framing
on
of
charge.
charge, what we have to see is the prima facie is if made against the accused.
My lord, I'm not opposing the framing of charge under section 21A
Okay, then what?
because age per contravene, because age per the record says
Hmm.
the what the learned code below supposed to frame charge. I'm not objected because there is only based the charge whatever material found in the charge sheet available in the record.
If there you have no objection with regards to the framing of charge by the land trial court, then what means?
we all submitted objection and also prayed this age per the record available. This case is
Now, this is not recorded after the evidence. In the evidence, you have to prove that it is only 5 vials recovered from you. You if it is on record, you prove that it is on record that it was found only 0.5, 5 or 15.
only five.
Five.
5
Five.
vials of
vials.
contraband substance was found recovered from you. You prove it. Record speak according to you, but then the court has taken together for the time being. Because they were traveling together, they were carrying in the bags, and then it could not be separated.
Bag, my lord, bag was already two bags recovered.
That is what I'm saying. That
From the
two
12
bags has been
person.
taken together now. Because it was recovered together. with
Apprehend
count.
together, my lord, apprehend.
It was
together,
not recovered
doesn't
from
mean
their
that-
pocket.
Apprehend together, it doesn't mean that accused person went for some common intention. Because other accused person, by that.
Then you have to prove that in during evidence, what I'm
My
saying.
lord, I'm praying for only based on record only. The record says only 5 files has been recovered and separate bag was
That has
there.
been taken.
So my
After
purpose,
that- See, after recording that, the recording, that the record says that from one bag, it was found 40, how much? 46. And from another bag, 5. Thereafter only it was, the learned trial court came into conclusion that since they were traveling together and the recovery was from bags, and that is why it was the substance for the sale purpose, and that is why it was taken together. Is also see the coming into conclusion. Let it come into conclusion after trial, after evidence. You see, so in the evidence that
my
it
lord,
was
purpose of this filing, because this person is drug addicted. When I have annexed the detox document also. If in this stage, if the present accused is get immunity from 61A of the NDPS, definitely the prospect of this present accused person will better. So that's why I prayed for
we
avail
can
this provision.
direct for expedite of the trial. Or what is your submission?
Your Lordship
That is
can
not
dispose of
today,
this
that's
matter.
it.
I'll just clarify with regard to my friend. He's submitting that section 50 also, since it was not his bag or 5 while was his bag. I'll just, there is a judgment of the
Yes.
Apex Court. I'll read paragraph this of 2023 7 Supreme 644. So Apex Court judgment, Ranjan Kumar Chadha versus State of Himachal Pradesh. I'm relying on paragraph 89, if I may read, Your Lordship. Thus, in Pawan Kumar Supra, the larger bench, while answering the reference in no uncertain terms, state that a bag, briefcase, or any such article or container, etc., can under no circumstances be treated as body of a human being. They are given a separate name and are identified as such. They cannot be even remotely be treated to be a part of the body of a human being. The that a person of varying capacity can carry different items on his or her body, but that does not make those items as a part of the body. The court observed, depending upon the physical capacity of the person, he may carry any number of item bags like a bag. It would be said that a person is carrying a particular article specifying the manner in which it was carried, like hand, shoulder, back, or head, etc. Therefore, Pawan Kumar Supra concludes that an external article which does not form part of body outside the ambit of the word person occurring in section 50 of the NDPS Act. What is more important to note in Pawan Kumar Supra is that the search was not only of the bag, but also of the person of the accused. However, the contraband was recovered only from the bag and not from the person of the accused herein. What we are trying to highlight is that although in Pawan Kumar Supra, the search was of the accused as well as of the bag, yet the recovery was of the contraband was only from the bag. This court took the view that section 50 would have no applications. So it's a very clear, Your Lordship. He clearly said there was a personal
That is why
search.
it was taken.
Yes. And this was
My
with
lord,
regard
uh,
to a joint position, and
That has been the case that there were some other passenger also,
Yes.
and you would have say that
Absolutely.
this is not my bed.
Even in a traveling car, many of the cases happen, Your Lordship. And therefore, my submission at this stage is that this, the impugn order that has been challenged, there is nothing wrong in the impugn order. And therefore, interference at this stage would, Your Lordship, in many manners
What
would.
I'll do is I'll pass an order giving you liberty to raise
Yes.
any, after the evidence is, after the evidence of probably the person who sees it, who clarify that it was under his
Yes.
possession, then you can
That
just
can always be a step.
make a prayer that since now it is clear that only 5 vials have been recovered from his possession, now it will come under this, and now it should be segregated. Again on Monday. List it again on Monday. List is matter on Monday.
Deeply.
Ablash.
Yes, Your Worship.
Yes.
So, Your Worship, the present petition is filed for seeking to quash and set FIR number 20,024, registered at W Place SEPA, Your Worship, under the section 65 clause 1.
The state respond. Issued staff. List is matter. When came? After 2 weeks. After 2 weeks. Is coming. After 2 weeks.
Any fixed date? No.
Not. List is matter. It will come by on foot.
No, sir. At least any fixed date, Your Worship.
Okay, then
Yeah.
what, when? Any date. Any date means when? Give a date. Then,
June.
19 June. Okay, 19 June.
File your please.
May I please?
Hmm.
My lord, is a joint petition. Uh, 324 IPC. The punishment is only 3 years,
3 years.
but not confirmed. And initially,
Case
matter
of
was
2016.
yes, pending before the Lanet Trial Court 0. And this case initially arising out of purely civil dispute case regarding land dispute, in which the escapal took place, and so minor injury was received by the present complainant. Hence, this case lost. And after pending
Agreement.
page number 16 is the settlement copy entered by the parties.
Where have you kept?
Your Lordship, if Your Lordship will come to page number 15, Your Lordship.
Please?
Number 15. 15, 1 5, Your Lordship.
Yes.
Your Lordship, down below we'll see list up on case also info for examination of DW5 and also for examination of DW number 6 and 7 of
Okay,
the.
okay, examination.
So the defense
Trial,
five of the defense witnesses has already been examined, Your Lordship. So it's
Okay.
a stage of
date of the defense. Okay, so
Defendant,
so the defense witnesses start.
yes. Even then, my lord,
defense witness has
against the
already
party,
started, Your Lordship. Five of the defense witnesses has given their
That is
statement.
also after, up to 4, it was defense witness examined up to 4. So now for 5, 6, and 7.
Because since the defense witness after 6 and 7, if we are not aware of if there are more defense witnesses,
Hmm.
Your Lordship. However, my only submission is that the trial is at the verge of completion, Your Lordship.
Mhm.
And then Lakshmi Narayan clearly states while referring to Narendra Singh, Your Lordship, that normally
Now-
the High
Now
Court
we
should.
do not know if there is prima facie, if they have established, that means if they have started defense, means there is a prima facie case against accused. Anyway,
I'll just
So-
place this citation only on the ground that when should a high court under 482 exercise their power, Your Lordship? If Your Lordship will see down below is the page number. It starts from page number 9, Your Lordship. Paragraph 12.
yes.
This is a reference being made to Narendra Singh, Your Lordship. That Your Lordship is well aware that Narendra Singh speaks of offense under 307, Your Lordship. Now, while referring to Narendra Singh, the court comes to a conclusion, which Your Lordship will find at page number 11. 29.7, Your Lordship.
Hmm.
If I may read, Your Lordship.
Hmm.
While deciding whether to its power under section 482 of the code or not, timing of settlement play a crucial role.
Hmm.
Those cases where the settlement is arrived at immediately after the alleged commission of offense and the matter is still under investigation, the court may be liberal in accepting the settlement to quash the criminal proceeding investigation. It is because of the reason that at this stage, the investigation is still on and even the charge sheet has not been filed. Likewise, those cases where charge is framed, but evidence is yet to start or the evidence is still at infancy state, the High Court can show benevolence in exercising its power favorably, but after prima facie assessment of the circumstance material mentioned above. On the other hand, where the prosecution is complete or after the conclusion of the evidence, the matter is the stage of argument. Normally, the High Court should refrain from exercising its power under 482 of the code. Now, my only objection, not as per objection, Your Lordship, I leave it to Your Lordship discretion, but this is at the
Yes,
stage of.
That is, but let us see if, because at this stage also, if he is on the apprehension that he is likely to be convicted, if he has done something else,
Yes,
then we'll have to look into.
yes.
We have to go beyond the.
Because
submission
since
to
this
counsel also.
petition does not speak about any of the merit
Yes.
of the case, only on the ground of settlement, Your Honor.
Hmm.
Therefore, because
We'll go for the.
more particularly, I'm objecting on stay because, Your Lordship, the trial is almost at the verge of
Stage
completion.
will be difficult at this
Yes.
stage. Because we have seen the stage.
Otherwise, Your Lordship can issue.
Prosecution witness is already examined.
Yes, Your
It and then. Okay. We'll call for the scan copy. Mr. Torum, huh? T. Torum, land counsel for the petitioner. Sarah, this is an application filed under section 528 of the BNSS 2023 for quashing of the proceeding in GR case number 164 stroke 2016 arising out of which PS case? 0 PS case number 107 stroke 2016 under section
324.
324 IPC. Stop on. Call for the scan copy of the GR case number 164, 2016. Issue notice. Since Ms. Jenny accept notice, appear and accept notice on behalf of the state respondent, no formal notice required to be issued. Start. List this matter. When can,
After 2 weeks, your lordship.
after
2 weeks, your lordship.
2 weeks? Okay. Matter after 2 weeks.
Your lordship, if I may also, your lordship, since there are two, your lordship, the informant, the victim as well as the accused, your lordship. Accused is Lisi Sem, who is the respondent number 2, your lordship. Likha Jamin is the petitioner number 1 is the complainant, your lordship. Victim has not been made a party, your lordship. Likha Peg has not been
Say
made.
joint petition.
If your
The
lordship,
informant.
if your lordship will come to page number 12, your lordship. So petitioner number 1, Likha Jamin is the complainant, your lordship.
So Likha Pek.
Likha Pak is the victim, your lordship, who has not been made a party in this petition.
Okay. And probably you have to make the victim also as party.
Yes,
Victim is an aspect party.
we'll make necessary amendments.
It is seen that the
I may be allowed to.
victim
necessary
of the victim in the case, Likha Pek, has not been made as a necessary party. The petitioner said. So in the event,
The settlement also does not
in
speak
the
about,
settlement also, Likha Pek is not there.
it's there, your lordship.
Pek is there. So, okay, the petitioner will take steps for impleading the victim in the petition. Okay? You in, okay. Within a week,
It's within.
okay? Within a week by filing. Amended course title. Okay?
Yes, your lordship.
And within the book and amend the course title. Okay? Okay.
Deeply obliged, your lordship.
Obliged.
Yes, I'm
Yes.
But this is my lord, the second appeal, my lord. Against the order dated passed in my lord 9 of 2024 in civil appeal
Second
number.
appeal against which?
Second
against?
appeal.
Second appeal against?
Against my lord, this is order in IA, my lord, number 94 of 2024 in civil appeal, number 30 of 2024, my lord. Before the
You're challenging which order?
order, my lord, 24 for 2025, my lord. Pass in IA number 94 of 2024, whereby my condonation application, my lord, for filing the appeal, my lord, has been dismissed, my lord.
That,
Only that.
only that.
Only that.
Let us see your prayer.
In this matter, I am submitting on behalf of Mr. Orin Modi, Your Honor, who has submitted his letter of absence here. This is second appeal, regular second appeal here. And we have objection to the maintainability of the second appeal here. So the conducting counsel is, since he is not present, Your Honor, I kindly, Your Honor, accommodate 2 weeks there, so that
Yeah, my lord.
maintainability issue is there, Your Honor. So my lord,
Yes, my lord.
They file revision petition?
Your Honor, that in fact,
And then in the revision observation probably has.
Yes, my lord.
And then you
Yes, my lord.
to file a first, and then you have filed this
Yeah,
second appeal.
Second appeal, my lord.
That is why I'm asking, because probably you are agreed by the decision of the Gambura,
My lord, my lord.
not Gambura, the Gambura,
My lord.
appellate authority.
My lord.
So the decision, Gambura decided in your favor.
Yes, my lord.
They file appeal
My lord.
before the
Gambura Association, my lord.
Gambura Association.
My lord.
And then Gambura Association agreed by, and then Gambura Association again overturned and decided against you.
My lord.
So you file appeal before the civil judge.
My lord.
Civil judge did not allow the condemnation petition.
Condemnation.
And now you see, you are coming before this court.
My lord.
This should have been, the first appeal been there, first appeal is before the Gambura Association.
My lord, my lord.
Second appeal is before the
My
civil judge.
My lord.
This, it becomes third appeal.
Yes, my lord. Truly, my lord. That's why, my lord,
So that is why I'm, my query is, you are agree by which order?
I agree by the dismissal of my condonation application, my lord. By the learned civil justice senior division, my lord. Now, my lord, candid enough, my lord. I also, yes, this is, my lord, second appeal against the second appellate authority, my lord. Therefore, my lord, I prepare, my lord, a civil revision, my lord. Now, I humble that issue has been decided by coordinate by the subdivisional court, my lord, saying that, my lord, no, it should be the second appeal, my lord. Accordingly, I have filed this. Otherwise, my lord, today, my lord, my humble submission is caveat is there, caveat is there, my lord.
Caveat is there.
yes,
My lord, it discharge the caveat, my lord,
Okay.
and next date, my lord, will.
Then in that case,
Yeah.
okay, but then you have to,
Yes, my lord. Next date, we can have argument, my lord, on maintainability and the certain question of law, my lord.
maintainability
And
also.
my lord, kind issue notice, my lord, as caveat is there, there is no problem notice required, my lord.
Where is caveat? Oh, maybe. Mr. You have of foreign Modi in cabinet. Foreign Modi in cabinet. Huh? Mr. Modi, the land council for the cabinet will be heard in view of the law. The cabinet stands discharged. Okay. Then. So this will be listed when you said
fourth
Next-
of
not issued.
Notice will be next week, my lord.
This will issue notice. Mr. Helper, land council for the appellant staff. Huh? Also had Mr. T. Omo, land council appearing on behalf of Mr. Corin Modi. Land council for the KBT. Is only sole respondent
Two respondent, my lord. Two respondent.
and Modi is appearing on
both both the respondent.
all the respondent.
Yes.
Okay, for the respondents. Huh? Stop. This is second appeal filed under the provision of section 100 of the Code of Civil Procedure 1908 against. You have challenged appellate judgment. Okay, appellate judgment in okay against the appellate against the it's a judgment at the okay against the it's let us see where is the impugn order?
Impugn order, my lord.
This order.
Page number, my lord. 48, my lord. 48. Connection number 1, my lord.
This order, okay, against the order dated 24 for 2025 passed in IA number 94 stroke 2024 in civil appeal within bracket Kebang bracket close number 30 stroke 2024. Any other?
No,
Whereby the learned trial court dismissed the IA dismissed the condonation petition filed by the appellant. Is call for the record is necessary.
a record will be necessary, my lord.
Call for the scanned copy of the IA number 94. Only this IA number.
And no, this IA is in the civil appeal number 30, my lord. This also will be required, my lord.
Okay,
this
then
IA is
call
not
for the record.
independent.
We'll say call for the record, huh? Call for the trial court report.
Hmm.
Issue notice. Since Mr. Omo appearing on behalf of Mr. O Modi accept notice on behalf of the on behalf of all the respondents, no formal notice need be issued. You served copy
Yes, my lord.
already. Okay. A is prayed, comma. A is prayed for by the Nana Council for the respondents, comma. This matter
Your Honor,
after
Your Honor,
when
on-
he's coming.
fix that, Your Honor, kindly accommodate, fix the 4th of August, Your Honor. For disposal, Your Honor.
No, my lord. This is second appeal, my lord. For before disposal, we need to
No.
frame the
Yes,
substantial question of law.
admission hearing is,
Yes,
admission,
in the second, it has to be listed for admission.
yes, admission hearing on
It
4th,
has to be
4th of August. Kindly
Okay.
fix that.
Let it be on the 30, my lord, then. 30 June, my lord.
30
Or July,
List it.
July 4th, my lord, anytime, my lord.
July 4 is holiday. If you want to take up in the holiday. No,
30
July 4 not holiday, I think.
Not holiday, my lord.
Then
Let it be on
July
July,
4 is the last date. Probably it will not be possible.
then 23, my lord, July, 21, 22, my lord.
Last part of July can be, we can
Your
fix,
Honor,
say 26
Your Honor, since the,
or 3rd July, 2nd July,
we are calling.
2nd July, my lord.
2nd July, okay.
High level. High level.
There are the three matters, 5, 6, and 7. First of all, Your Lordship, my member here, item number 6 may kindly take. It is item number 6 may kindly taken. It is a petition for quashing of FIR.
Item number
Lodge
6.
item number 6.
Which one is 6? 6 is
Case number 157.
157. Why item number 6?
Because my lord, all the facts are similar. And if Your
So this is the
Lordship,
best for you.
it is a bad for me. my lord.
Okay.
Page number, my lord. 17, annexer A.
Just a minute. You are representing respondent, Mr. Talo.
Yes, my lord.
You are representing why also.
Yes, in 5 and 6, respondent, in item 7, I am the petitioner.
And my lord, in number 6, I'm fearing for the SIT, man.
Just a minute. Is there any interim
In item number 7, there is a
in other?
5 and 6, there is no interim.
No interim.
My payers, my lord.
What is the difference between 5 and 6? No,
7 is matter filed by the wife in which where when maintenance has been rejected by the trial court. So she has challenged that order in the
Seven.
item number 7.
item 7.
Yes, my lord.
Okay,
And item number 5, it is for caution for domestic violence. Application for caution of domestic violence case filed by the wife.
Hmm.
Item number 6 is caution for FIR lodged by the wife under section
It's
498A.
different, it's different. Then
The facts, I am saying, my lord, facts are same. That when marriage has been solemnized and what happened in during the till the application has been moved before the police station. Other other grounds are differently taken in domestic violence act. So my prayer was that, my lord, because first FIR was lost,
Hmm.
then domestic violence application has been moved by the wife. So
first
therefore,
FIR was lost
first FIR was lost
against the husband.
against 8%, my lord. Husband and
FIR for what?
FIR under section 498 है, that there are demand of dowry or due to non-fulfillment of demand of dowry, there were assault, physical and mental.
Okay. Then thereafter,
Thereafter, she also,
that is this item 6.
yes, ma'am.
Okay.
Then she also moved application for registering the case under the provision of Domestic Violence Act
Against husband.
against
All-
the 8%.
That is item 7.
In item 5,
Item 5.
yes, ma'am.
Okay. Then
And she moved also,
item 7.
yes, ma'am.
Okay. So this is 3 different cases. The
Yes,
3
ma'am.
cases are
Yes.
arising out of the same
Yes,
person.
ma'am.
Okay.
The
Between
basic
same person.
facts are same.
Now you can go ahead, please.
Yes, ma'am. Annexure A is the application and the FIR.
Annexure.
Annexure A, page number 17.
17.
Page number 17.
This was way back in the 2019.
Yes, ma'am. 5.2000.
First, let us clarify what is the status of the case?
At this stage, my lord, charge has not been framed. Charge sheet has been filed.
Otherwise, charge sheet filed. Charge not yet framed.
Charge not yet.
You appeared otherwise.
Yes.
Why charge not yet framed?
Last 2 days, the proceeding officer was on leave, my lord.
Is there any stay? No.
No, there is no stay, my lord.
No stay. Okay, yes, let us see.
So, my lord, this written complaint was moved on 5.2019.
Hmm.
Here, application in para 2, my lord, may kindly see. The brief facts of the case is that on 20th/4/2018, my marriage ceremony was solemnized as per customary rituals of Hindu marriage in the presence of family members of both the parties, including relative at Derapur, Kanpur. On the next, after the marriage ceremony is over, my lord, may kindly noted that, my lord. On the next date, Next, after the marriage ceremony is over, Bidai ceremony was concluded, and I was taken to husband. Thereafter, to my utter shock and surprise, my husband, including his parents and relatives, started torturing me mentally and physically. Started demand dowry. When I have informed about the incident to my parents, they snatched my mobile and physically assaulted me with the warning to face dire consequences. My father was forced to pay an amount of 20 lakhs as dowry. Even after paying the demand dowry in different installment, total 20 lakhs, they again intimidated in case failed to pay another demand dowry amount of rupees 20 lakh. They will not allow to stay me at husband house. The entire family member of my in-laws torture me emotionally and physically, traumatize me, kept in storeroom without food. So these are the basics allegation on the husband and family members. Now, may kindly see, my lord, the FIR is so long, my lord. May kindly see page number 19, but the FIR has been lost, my lord. Page number 19. It is also part of Annexure A. On 7th of January 2019, after 2 days, FIR was lost. It was against 8%, my lord. Page number 19, my lord.
Yes.
19. My lord, on the next page, page number 20. My lord would see there are 8
This-
accused person.
This 19 is the registration of FIR.
Yes, ma'am. After 2 days.
After
2 days.
2 days. Hmm.
Page number 20.
Yes.
With due respect, I beg to state I am presently residing at so and so place, district Kanpur, Dehata, to the effect that on 24/18, a marriage ceremony was solemnized as per customary rituals of Hindu marriage at Derapur, Kanpur, in presence of both the parties. After marriage, she taken to her husband Shri Harendra Badoria home at GL 320 DD Nagar near Temple Gwalior. Thereafter, to her utter shock and surprise, her husband, along with his parents and relatives, namely, my lord, may kindly see, namely Surjit Singh, then my lord Ram Naresh Singh, then Urmila Devi, then Ashu Badoria, and Santosh Badoria.
This is not in the FIR.
Yes. Only these names are there. No name of Reena and Priyanka are there.
Yes. So in the statement, probably she has included.
Yeah, but in the statement, they have updated their version, my lord. So there are each and every stage, my lord. There are different version of the wife. In the complaint, in written complaint, she mentioned different version. In the FIR, there's different version, and their
What is the
statement
different-
also.
What is the different version?
Well, because what she's saying, my lord, my lord, I request to note, my lord, on the next date after marriage marriage ceremony means marriage ceremony was solemnized on 20th 4 2018. So after marriage, demand of dowry was made out. according to this written complaint, my lord, she is saying after 20th 4 of 18, when ceremony was solemnized, marriage ceremony, I came to the house of husband. That demand of dowry was made out, my lord.
This FIR is same with the written FIR on 5/1/19 or different?
5/19 is the application, written application. She is mentioning that after solemnization of marriage on 20th 4/18, demand of dowry was started. And due to non-fulfillment of demand of dowry, she has been assaulted and she has been locked in the room. These are the basic allegations in this written complaint.
This
And
this column
such
12,
type of
this-
version is not
just-
in the
just-
FIR.
This column 12 is brought from where?
In column number 12, my lord,
This FIR is brought from where?
it is start, my lord, to the effect that on 20th 4/18 marriage ceremony was solemnized.
No, this first information contents was brought from where?
Brought from the written complaint, my lord, because
Where is-
my lord,
which-
my lord would
which written
see
complaint?
this 5/4/19.
So that is why I'm asking.
Yes, may I, because
Whether in-
my lord, may
whether
kindly
in-
see the
whether in
chart,
written
part of chart. May-
Complaint 5/1/2019. All
Your
these
Lordship, may
names-
kindly see
names-
that-
all these names are mentioned.
My lord,
Whether in the written complaint 5/1/2019,
yes, my lord.
all the name mentioned here, Sujit Singh, Ram Naresh, their name has been mentioned here.
The name has been mentioned. The name is not mentioned in this application, my lord.
Then where from this has come?
That is the my ground, my lord, because when she has not mentioned any name in the complaint, my lord.
That is why I'm asking. You have not mentioned, so because I was confused, because this is different, this is different, this, whereas
So,
this
my
should
lord,
have
that
been
is-
the same one.
Yes, my lord. No, my lord. Name is not mentioned in the written complaint. But she has only said that my in-laws and all relative or relative of the husband. She has only said in this written complaint that all the family members, the relative of the husband. And in the FIR, she has only mentioned 5 names, my lord.
FIR, where? You have not read entire FIR, that is why it's difficult.
Your Lord, FIR start from page number 19. And it ends on page number 20, my lord. This is the FIR, my lord.
No, this column 12 brought from where? Same thing.
Column number 12, my lord, is this FIR lost on 7/1/2019.
Is it the same?
No, this is not same, my lord. That is my ground, my lord, because their version is different. In the FIR, there is different version. In written complaint, there is different version, my lord. And their statement also, she has
Now,
mentioning
now
different.
then the police is playing against you.
Yes, my lord. Because my lord, the father of the wife is
Father of the?
father of wife.
Huh?
Father of wife
Huh.
is serving in police department. He is a SI in district Itanagar.
Where? Itanagar.
Yes, my lord. He is a SI in district Itanagar.
This FIR was lost, not at
This
Itanagar.
FI was lost in Mahila police station.
Where?
My lord, may kindly see.
Itanagar,
Yes, my lord. Woman police station.
women police station.
So my submission was that, and my ground was that, my lord, all the proceeding
Where is
is
PP?
manipulated by the father of the wife, my lord.
Yes, where is PP? State is also the respondent.
Yes, ma'am.
You are for?
SIT, my lord.
SIT.
Yes, my lord.
So I am confused. Normally, what is being done is the written FIR, the complaint is reduced in this column, first information content.
Yes, my lord.
So this seems this is different.
Yes, my lord. It seems FIR which
Because
has
now this I have to come across first. Why this? No? I have to come across.
yes,
So okay, is it possible or how it is done? Or
my
is
lord.
it, can
My
it be
lord,
done?
actually, my lord, the pleaded case of the petitioner is my lord. Only that, my lord, since the alleged offense was taken place at my lord Gwalior, UP, which was the matrimonial home of the respondent man, wife man. So that FIR could not have been registered in Itanagar, man. That is their pleaded case, my lord, in entire petition, man.
So now if this is done, say for example, the written FIR, the complaint at page 17 on 5/1/2019 is written FIR. Okay. So while registering in this column, first information content, in the content, the same what has been stated in the FIR should have been reproduced, isn't it? So, but then here it appears, although he has not read entire FIR, that is what I'm saying. So normally what you have to do at the time of hearing, you have to read entire FIR. When you are
My lord, the whole case is manipulated by the father of the
especially-
wife, my lord.
especially in the case where you are disputing the FIR, you have not read it entire. So this is different. If this is done, then naturally they will have to file the outside state if it is done in Arunachal Pradesh.
My lord, their case is, my lord, is not that particular person has not named the FIR to strike out particular person from the
No,
charge
no.
sheet. That is not their case, my lord.
Just a minute, huh? In the complaint, in page 17, how many names of the accused persons have been mentioned?
In the complaint,
Hmm,
my lord, asking for FIR or written complaint.
written complaint.
Written complaint, there is no name mentioned, my lord. Only says my relatives, my relative of my husband.
See, just a minute, huh? Then, see, no name has been mentioned in here in page 17. But in page 20, while recording the FIR, so many names have come, 5. And in the name of the accused, again in the list, 2 more appears added again. One, Reena Singh and Priyanka Julie.
My lord,
So
that can
how
be
it is done?
that can be added during course of investigation, my lord, because
During course of?
the course of investigation, my lord, because FIR is not in encyclopedia of entire facts, my lord.
Now, at the time of charge sheet, filing charge sheet, that can be added.
Yes.
But then not at the time of recording the FIR,
My lord, it is
registering
of course,
the FIR.
Well, it is of course there, my lord, in the written
At the
FIR.
time of registering the FIR, what is in the content? What is the content of the FIR is to be reproduced here, and
Yes.
the name also
Yes,
cannot add.
that I can understand, my lord.
Thereafter, after investigation, so many name can be included, and then of course the section can also be altered. Hmm? And then the higher section can also be inserted with justification that during the course of investigation, these are the
My lord,
findings.
but their case is, my lord, that this Itanagar PS has no jurisdiction. Since the offense,
Not the question of
that is their
no
case, my
jurisdiction.
lord.
Not on that at the moment. That is raised, but then my question is here. Why Idanagar PS case has done this? Is it permissible? Because altogether different. The case cannot proceed beyond this. After clarifying this only, the rest will proceed. Isn't it?
My lord.
Because here it's confusion, created all confusion. FIR different, and then the register different. With all names, which was not spelled out in the written complaint. Why it has been done? Who has done? I think the police, the authority has to see who is the person who has registered this, who has received the complaint and registered it differently, added so many things, names, and then in the list different, and in the content different. And this entire register, the content is different from the written complaint lodged by the informant. So this is total improvisation. The police, how can the police improve the FIR? Cannot. After investigation, I understand. After findings, so many things can be done. But then this, how? Okay, anyway, this lacuna you have found out. Okay, then please, please take your seat. Yes,
Now, my Excellency, my lord, I have filed an IA for taking additional facts and documents on record. Because, my lord, what is the allegation that on 20th 4 2018, when marriage ceremony was solemnized and demand was started for dowry.
demand,
After ceremony, demand of dowry was started.
that is in your FIR only.
Yes, my lord. So, my lord, I have filed an IA.
You are for the accused.
Yes, my lord.
Okay,
So I have filed an IA to show this court that the entire allegation in the FIR of demand of dowry also false, my lord. May kindly see my IA, my lord.
IA indeed.
IA number 20. In this case, my lord, I have filed an IA.
IA in 157.
Yes, my lord.
IA 20 is 157.
Yes, my lord. My lord, may kindly see Annexure N, page number 54. Page number 54, Annexure N.
M
Yes, my lord.
and
This is the scheduled program of exams, my lord. Chhatrapati Shahuji Maharaj University, Kanpur.
what is this?
This is the exam program, my lord. In the last, my lord, would see, my lord, on 20th 4 2018, Sunday. The exam of botany maths was conducted, my lord.
Date when is
22 4 2018. On the last, my lord would see the date mentioned in the sequence, my lord, in the last. In the last row.
2018 Sunday.
Yes, botany maths. My submission is that on this particular date, after 2 days of marriage, she was appear in this exam. And their result was declared on page number 56, my lord. Page number 56, may kindly see, my lord.
This is on which date you said?
24.
Marriage?
Marriage was solemnized on 20 of 4. And exam was held on 22nd of 4th. After 2 days of marriage.
2 days of marriage.
Yes, my lord. She has been appeared, my lord. May kindly see page number 56. Annexure O, page number 56. This is the result declared by, again, Chhatrapati Shahuji Maharaj. Their name mentioned Rashmi Rekha. Father name Surendra Singh.
This is the same informant.
Yes, my lord. Informant name Rashmi Rekha, daughter of Surendra Singh.
How do we link it?
My
This is on which
lord,
date?
what she is saying in the FIR, my lord, in the written complaint FIR, that after the marriage, she was assaulted for demand of dowry and she has been locked in the room, my lord. My lord, may kindly see.
Her allegation is immediately after marriage.
Yes, immediately, my lord, may kindly see. Because no date has been mentioned in whole FIR, my lord. On what particular date demand of dowry was made, what particular date she has been assaulted, no date has been mentioned. She is saying immediately after the marriage.
Because thereafter, this is only, the FIR is not the encyclopedia of the entire fact. Thereafter, she has given a statement before the police And now after, and then other witnesses have also given statement before the police, and thereafter only the charge sheet filed.
Okay,
Now, we
my
need- we
lord,
need-
now may
we
kindly
need to
see.
the record, what she has stated, the demands, when the demands started, the assault, when the assault started after the marriage. She
Yes,
must
ma'am.
have given
Well,
that.
I have two grounds, my lord.
Hmm.
First, that one, she is saying that demand of dowry was started after the marriage. So I have two grounds, my lord. When she is appearing, it means that husband is helping to the wife to appear in the exam. She is helping husband. He is helping husband, and he allow her to go in the exam, to go for the examination and appear in the examination. So there are two grounds, my lord. First is that demand of dowry is not made out, my lord. And second is that the husband is helping husband.
Now, we do
Is
not-
helping.
That is different. That the fact and the merit of the case is different, altogether different. Just a minute. So. Let us.
And my lord, I have also annexed the WhatsApp chatting of the husband and wife.
Now, if you are contesting on merit, then you'll have to face trial only.
No, my lord. What I'm trying to say, my lord, the whole the allegation. Whole the allegation,
Okay.
because the father of the wife
us
is
see.
manipulated whole
There is
the
a
matter.
record, there is a record charge sheet filed.
Yes,
Let
my
us see the statement of the victim or the informant.
yes, my lord.
Statement of the informant.
No, it's a statement of the
Informant.
informant. Yes, my lord. Be kindly. A statement of section 161.
Yes. Have you annexed?
Yes, my lord.
Okay.
May kindly see, your lordship, page number 56. The statement of the complainant, Srimati Rashmi Rekha. In this statement also, my lord, she has not mentioned any name of the family member of the petitioner. May I read, my lord?
Yes. The same statement she has probably given. You know, what she has
So,
given,
my lord,
stated
the
in
basic,
FIR.
the main allegation is that, my lord, after the marriage, she has been locked in the room and she has been assaulted. This is the allegation, my lord, because demand of dowry was not fulfilled. So that is why I have produced these documents, my lord, that she has not been locked in the room, my lord. That allegation are false allegation.
No, she said that initially for only 2 or 3 days, he had shown interest only for the purpose of the, okay. So 2, 3 days.
Yes,
there
my
was no
lord.
this-
That is
It was
my
after
submission.
that only.
And my lord, now may kindly see, your lordship, page number 82.
So the examination and this probably the immediately after is not correct what you have submitted, because she has clarified that initially for 2 or 3 days he had shown interest only for the purpose of having physical relation. Thereafter gradually started losing interest. Thereafter only, see. Not immediately, huh? Not immediately. Don't submit like that. There is a statement. You have read it earlier. if you make such submission, then we have to clarify and then it will prolong to clarify.
Your Lordship, Your Lordship, may kindly see Your Lordship,
If
page
you
number
submit
82.
properly and then the correct submission, that we believe that learned counsel. Why
No,
should you
my
allow
lord.
the judge to judge?
So, my lord,
Everything.
basic allegation is that, my lord, immediately after the marriage, she has been locked in the storeroom.
After only, slowly, she has clearly stated that thereafter, slowly, he gradually started losing interest upon me on the pretext that my skin color is dark and color ugly.
So, my lord, this version is not in FIR, my lord. My lord, this version is not in FIR and not in the private complaint, my lord. That is my ground, my lord.
FIR is not the encyclopedia of the entire truth. It will be given in a statement. Statement is the entire.
My lord, this is the change of version, my lord. Where, my lord, in the procedural of section 42, my lord should consider these facts, my lord. What they are doing, my lord? She's updating their version again and again, my lord. In the FIR, they are different version. In private complaint, they are different version. And now again in section 161, my lord, there are again different version and different allegation, my lord. And just because their father is serving police station, what he's advised to her daughter, she's changing their version again and again.
Marriage took place when? It was April. Where was the FIR?
Page number 19, my lord.
Okay. Marriage took place marriage, okay. 20. So, okay. There are on 14 June. Now you see, there is a allegation of demanding. And then how do we come into conclusion here? How do we appreciate the evidences unless we examine and opportunity is given to you for cross-examination? How do we come into this conclusion?
What?
Because
My lord,
now
what
the
I'm
trial
trying
is
to say,
pending.
my lord,
There is a serious allegation.
if any matter, complainant changing their version in different stages on such type of cases.
You take this plea
the
before
control-
the trial court.
It
You
is
raise it, you
it's a matter of
demolish
caution,
her
my lord.
evidence.
If the allegations are different, my lord, I am giving the material that evidence are false, my lord, because what I refer this
Now,
honorable court, my lord.
Now,
And my lord, one more.
See, you have an opportunity to raise these issues at the time of framing charge against the accused persons. Because initially the allegation is only
My
against.
lord,
the
my
applicant.
submission, there is no prima facie case to made out, and the allegation is false, my lord.
How do we know unless it's he?
Because my lord,
cross-examined?
I am giving the material, my lord, and more
What are the
documents I have filed along with IA, my lord. I have filed the,
How do we find out that this?
I have filed, my lord, page
no
number
demand
82,
was
may
made?
kindly see, page number 82, may kindly see,
And
my
at
lord.
this, the examination that which you have shown that she was given an opportunity, next second day, she made an allegation, but then the second day she was allowed to face examination, but she has clarified that for a few days it was all right. See, we don't have.
My lord,
we don't have a-
in the 161
We have
statement,
no-
she has
no-
completely changed their version. She has completely changed the FIR, my lord. What she has stated in that 161, there's no,
161 statement, in the detailed statement, she can elaborate it. She can elaborate. In the FIR, only two line can consist an FIR, entire FIR. But then at the time of statement.
my lord,
statement,
that can
161
be
statement,
happened
she
when
can-
the oral FIR has been lodged, my lord.
Hmm.
In 2 lines, FIR can be lodged, my lord, but there must be oral FIR. There is a written complaint, my lord. There is written complaint where different allegations are there. FIR are lodged in different,
No,
in different.
allegation is same, but then she has elaborated here. But the name insertion of the
Name also not there,
name
my
is
lord.
different. So that's what I'm saying is the name, since there is no name. She has also
Madam,
name
hold the-
commonly saying that the entire family is involved. Then at the during the time of
So,
investigation.
my lord, that is why I'm saying that it is abuse of process of law, my lord, because
No.
whole the
No.
family member has been.
No, during investigation, in the FIR without name also, FIR can be filed. But then during investigation, the name can be, you see. after
During
such
the
a-
investigation, it can be done, my
The
lord,
charge
but
can be
when
filed
there is a
against
written
any name.
complaint, my lord, when there is a written complaint. If suppose it would be a oral FIR. On the oral complaint, FIR has been lodged. That is the different thing, my lord. When
No.
there is a written complaint, my lord. FIR cannot be changed from the written complaint.
No, FIR
It
cannot.
means that there is
That's
two
not-
different FIR, my lord, against the petitioner. Because this is the first information, this also can be considered a first information report, the written complaint, my lord.
Different FIR means?
Different FIR means that complaint also should be considered FIR, and this FIR in the form so registered on
No.
7-1.
No, what
There
is?
is also FIR, my lord.
What is in the charge sheet then? Let us see the charge sheet.
Yes, my lord, may kindly see the charge sheet. Charge sheet, my lord, is as page number 62, my lord. And their contents start from page number 73. Paragraph number 60, brief facts of the case.
Oh. We may have to continue at 2. We'll continue at 2.
My lord. After lunch, my lord. After lunch.
Yes. Yes, let us just. Sixty? Yes, where is the name of the accused persons? 70? So this is the same, which we have found in the FIR. Just a minute. The name of the accused is here 8. And here 7. We start with 2. Hmm? No, okay. What is this 73? Oh, okay, 73 is witnesses. How many accused? 8. Okay, same. Against Reena Singh also? Priyanka Julie also? Okay, where is the operative last charge sheeted against? How many accused? Where do we find the name Hirinder Milan? Page number 70? No. Under the fact and circumstances, come to page 75. It was, okay, 1, 2, 3, 8. Yogendra. For offense, what is the offense? 498, so and so. Okay, let us come to the just statement where the informant has given some statement against the accused number 2, 3, 4, 5, 6, and 7. Whether she has named. Anyway, we are not going to that extent. So, but charge sheet filed. Where was her statement? Hmm? 56. Just a minute, huh? Hmm. Last para. 57. 56. Where? My husband, all the family members, namely so and so and so and so. How many numbers? Family members. Surjit. Okay, including husband, it will be 8 then. Okay. What are so this tally with the name given in the chart sheet. Okay. Okay, just a minute, just a minute. Don't worry, don't worry. We are hearing you since morning. For clarification, just a minute. Huh? Where is the name of the persons whose name Reena Singh and Priyanka Julie? Has she named Reena Singh and Priyanka Julie also in that paragraph? The 70, which paragraph it was? Yes, statement of the 56 last para. Okay, whether the name of Reena Singh is also there, just find out. Reena Singh is, she has taken the name of Reena Singh. Surjit, mentally tortured. Ram Naresh Singh. Urmila Devi. Ram Naresh, Urmila. Brother-in-law. Asu is Badoria. Wait, which one is Asu Badoria? Singh, Asu Singh. Asu Singh is the Badoria. It is same. Santosh Singh, huh? Then Asu, who is Asu Singh? Who is Asu Badoria? Badoria's name is not in the FIR. Santosh Singh is there. Who, which one? Asu. Santosh Singh. Santosh Singh is,
Wife of the petitioner.
how Santosh Singh can be, Sri Santosh Singh, how Sri Santosh Singh can be wife?
He's the third of the.
Hmm.
In his account, the amount for less was deposited.
Reena Singh is there. Priyanka Jolie is there. Surjit Singh. Where do we find Surjit Singh's name? Yes, Surjit is there. Okay. Yes, she has taken name and then there is an allegation against them. I think better you take because you say that charge not yet framed. It is fixed for the framing of charges. File an application before the trial court for discharge. Hmm. What document cannot be shown? Document, whether the accused person has given this document to the IO of the case during investigation, then it will be in the record, on the record only. Charge. But it was, at the time of your production, it was seized. Seizure memo must have been given to you. Oh, that cannot be. That cannot be. You have to bring and produce before the eye of the case and then state. No, no, no. Everything cannot be online. Hmm? And now you will say the option remain with you is to appear before the eye of the case and produce the document and then obtain seizure list. Oh, when have you produced? No, no. This is the problem, that you think that everything on postal and then you can appear before the how your document can how your document can be considered when you did not produce the same before the eye of the case who is investigating the case. Postal, whether postal no. No. That's difficult. You want that your arrest should also be made online. Yeah? See, there is a difficulties. If they have not received, what can we do? Don't always go for the easier way. What is those documents, by the way? You'll get an opportunity to in your defense.
WhatsApp chat between the husband and wife, where both are enjoying the relationship till May 2018. After 1 month of marriage, they were good relationship, and later on in the September 2018, she married by her father, and she has left the.
These all involves with the fact, dispute of the fact, which can what is document where IA? This is not a trial court, yeah, for your kind of information. Number one. Yes. That is why. That is why he is submitting. No. See, what I'm trying to say is these are the documents. According to you, it was presented to IO through postal. What is the practice here? What we know is that you have to appear before the IO of the case and present in person that these are the documents. At the time of recording your statement, whether your statement was recorded, then why you did not provide? Now you see, when you present the document, that normally you are conscious persons, you could have obtained the seizure memo, seize this document in the case and give me a copy of the seizure memo. Now, how do we believe? Now, how do we believe that you have presented this? Now, even if you have not presented this, or even if it is not included in the charge sheet, then after the prosecution evidence, you will be given an opportunity to adduce evidence, to produce witnesses after 313. Or how that is different? This document you present. Hmm. Hmm. Now in the 482, what is to be considered? No, just a minute. In 482, you want this document to be considered for evidence and then dispose of the matter. How? Kindly show that the High Court has functioned as a trial court, appreciating the document. Hmm. There are 23 of, well, there are 23 of what? Yes. No, see, at the time of framing charge, that is true. Those only the records or the documents or the material available on record only will be considered. But then you see, after charge, after framing of charge, if you are aggrieved, again you have the liberty. You can file if you are aggrieved. But then during the trial, in your defense, you can produce all these documents. See, even if in the charge also, probably on the, because on the face of it, there is a prima facie case against you. And then at the time, if there is a prima facie case against you, and then especially when the informant is objecting and the prosecution is objecting, it's very difficult. Informant is objecting and there is no consensus. Whether it is false or correct, true or false, will be, you see, that will be decided after the trial only, in the trial only.
If the complainant doesn't mention any particular allegation on particular accused person.
Here they have the allegation, there is allegation, clear allegation, specific allegation made. She has made a specific allegation. No, that is why if there is no allegation, then for the person against whom there is no allegation, you make a submission at the time of framing of charge. You file discharge petition. You see, you have option, and why you take advantage of? Okay, what I'll do? Mister, what is your submission, by the way? Anything? Yes.
Their main ground was that this incident happened outside another place. The affair was lodged in another place. So the police station here did not have any jurisdiction to entertain the investigation and file the charge. There was their contention in the criminal. Now, my lord knows, in accordance with the statement by Honorable Quality, where a victim gets sheltered, that place as a jurisdiction to entertain and FIR in regards to any incident they may have occurred.
You provide a copy of that, Mark. So this is the contention raised in the criminal petition.
Now, when we raised that, they came up with an item saying that this additional factual on this additional factual, putting my lord will fail. Their first petition, there is no whisper of anything regarding the matter. Only jurisdiction is there. Now, after we have raised the issue, they come up with a factual part.
Okay. So factual part this court cannot.
The petitioner has been constantly saying that there is an improvement, but if the FIR in its court is seen, my lord, what the FIR is? FIR is that I was married, I was subjected to.
No, that is clear. Specific allegation.
It is not that in the FIR it is only said that my husband beat me up and subsequently she is named. In the FIR, it was stated my husband happened and subjected me to cruelty or doubt. In one system statement, only the name of the person can be included. Nothing varies. Everything is the same. The narration is not.
But with regards to the person, there are 7 persons. That probably was initially in the FIR, in the written complaint. Probably she has not mentioned. But then subsequently, probably only after her recording her statement, it was included. But then that confusion is still there. If there is no any allegation against a particular allegation or a specific allegation against all those other accused persons, that of course will be a difficult path for you. That is it. Court.
However, it was registered in
After 2 days.
Yes. So in between my lord, the IO conducted an inquiry and then she must have gotten a name and then she must have registered this FIR.
It was 5th, yes. Okay. That part probably during the trial, IO has to clarify. Okay. And then, of course, in the case diary, if it is available that during this period, 2 days period, if he has examined, and after examination or if he had included, that is different.
Yes, an option is there for them
Hmm.
to go for a trial court and present it. And then
Yes.
for it to be ordered. And then my lord, what is the petitioner is saying regarding sending the note. If my lord, you see the record, his statement was recorded in the month of June. It was recorded on 7/6/2019. But the letter that they are claiming has been sent by registered court of the month of November. It has been sent after submission of giving his statement.
Hmm.
It's not yet yet,
Okay.
it's an afterthought.
Okay.
And more in regards to political matter, as my lord is clearly indicated, if what they are trying to bring on record, it will amount to a mini trial being undertaken by this honorable.
Yes, yes.
Because if our materials cannot be accepted as truth on the face of it, then their materials can also not be accepted as truth on the face of it. Their materials will also need to go under scrutiny and to be proven. That is there.
Okay.
Actually, if they are disputing the factual part, my lord, then my lord, I believe.
Okay. Yes. What is your submission? And then this part, probably you have to indicate, you have to inform the authority that these things are there, these things have been found. How it is applicable or how, whether it is maintainable. Can it be allowed? Just ascertained and inform. I think you need to, as a council for the department, you need to inform them that these things are there. Yes, what else? Hmm. Page? Hmm. Yes. Oh, Apex code dismissed? Page? 7, 8. Dismissed. Okay, so now you are no longer insisting for the transfer? Hmm. Okay, okay, yes. Hmm. 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 So that judgment you produce, okay, and then mark the relevant paragraph. Okay, so I'll dispose of, and then even if it is not allowed also, but then a liberty will be given to you to raise it before the trial court. Hmm. With appropriate application at appropriate time. What is the paragraph? We will ever hold that. Yeah. And the other case, para? 13. Okay. Okay. So this, which one you are relying upon? page. Dhananjay, para 18. Dhananjay, what it says? Just para 18 in page 7. Just a minute. 13, 14, 18, page. Para? You say para? Para 18, page number 9. No. It's- Oh, you are not not Dhananjay, Digambar. This. Just a minute. Just a minute. Yes, the ingredient. This is in what case? This is in what case? Okay. Which one you are reading? 23 of the same judgment. Fourteen. Yes.
Hence, it was clear that quality is not enough to constitute the offense. It must be done with the intention to cause grave injury or drive the victim to commit suicide or inflict grave injury to oneself. In the present case, the allegation given in the FIR do not reveal the existence of any such allegations. The only allegation that refer to an injury being inflicted against the complaint is the vague statement that the sum of the appellant is used to beat her, but there is no specific allegation of any such injury being caused by the appellant there.
There is a case where made the dowry demand and there is a evidence of payment also. Okay.
Grave injury and for the victim to commit suicide. So there is no such type of cause grave injury or drive
Okay,
the
okay.
victim
And
to
what
commit
else?
suicide
And
or
what
drive
else?
the
What else? Okay. Hard, Mister? Hard, Mister? Okay, Lana Council for the petitioner. See, no? Just-
A particular date and specific allegation in the FIR. On that condition also, FIR would be for.
You are Mister Rohit Jagwani, Lana Council for the petitioner. I've also heard, Mister. Hello, is for respondent number? Okay. Just a minute. Okay, Mr. Okay, yes, I think, and Mr. Talo for the respondent number 2. Yes, what?
There is a statement on the victim. There has been a technical statement by the victim that you being confined in the room. See, attended to the that may be confined.
Okay.
You will keep it there.
Okay. So, just a minute. What is your prayer? Okay. So this is about 157. It's all the same, yeah? Other matter is different. I think the domestic violence case and this case is all the same. Not the maintenance. Maintenance is different again. Maintenance, are we paying any maintenance? Hmm? So you want different date for this maintenance item 5 and 7. For item 5 and 7, you want different date. You want, huh? You say that this is same. What the difference it would be, the submission? What is the basic challenge?
Basic that my basic ground is that there are 8%. And domestic violence.
No, which one you are taking up?
Item number 5.
Item number 5 is about domestic violence.
Domestic.
Okay, yes. It's same.
It's about 45.
No, what is the status of the domestic violence case?
Reply has been filed and evidence does not get used.
Evidence is ongoing now.
Reply only file.
Evidence ongoing.
How many person have been made and is accused here in this case?
The husband and the family members.
Hmm?
Husband and the family members, madam.
Husband and
The family members, the same people.
entire same.
The same part.
Okay, the allegation also.
Same. Everything is the same.
Okay, this is all the same then.
Here,
Here the only the
the problem of domestic violence right now. Because I have got higher petition alert. There are 8% and they are not living combined. Petitioner number 1 is having residence of B9320. And the residence of 2 also same. And the petitioner number 1, 2, 6 are residing combined. The husband, father and mother. But other person living separately. So there is no domestic relationship with the complainant and with these petitioners. So when there is no domestic relationship between the parties, there cannot be domestic violence. May kindly see the provision of domestic violence act now.
okay, just a minute. What is the next step in the after filing of reply? What is the next step in domestic violence case?
Evidence will be started, they will produce their evidence. And their witness. Thereafter, I will produce my
Whether in the domestic violence case, no charge is framed.
charges, no, there is no provision of charges.
That is
At the time of,
after the reply, it will straight away start the evidence. After filing of the reply or your objection, you have filed objection, you said? Okay, then straight away it will start the trial of the case by recording evidence.
the trial has been started.
No charge is fine.
No, charges is not, there is no problem in procedural. In the judgment, at the time of judgment, they raise the issue and decide the matter.
Okay, so that means in the meantime, you, in the reply, separately filed, all of you have filed in the
No, all the 8% filed their reply, filed.
combined.
All the grounds have been taken, what I am mentioning before this honorable that they are the person who is living separately.
Is there any stay in this case?
No.
Today,
The trial court proceedings are proceeding. The witnesses are being examined.
Hmm.
The last witness is remaining.
So when do you want this matter? Next week?
After 2 months, next week, I will possibly comment where there is 2 days, this time between Gwalior and
My lord, after the
Oh, you come from?
I'm coming from Gwalior.
Okay,
There's 2 days.
then in item 5. On the prayer of both the land council for the parties are present. On the request of the parties, list this matter again. The earlier was in 6, item 6. That will be disposed of, 27 of 27 June.
my lord, I won't.
Then when?
My lord, after the break, my lord, immediately
After
after the break.
vacation. So that will be after second week, third week of the July. After third week of July.
Next date will end.
When? You just indicate you, since you come from outside. Third,
22.
22.
22.
Okay, 22 July. This and 7th.
And my lord, in 7 we have a prayer. In item number 7,
Yes.
we have a prayer. Firstly, the interim may be kindly continued, and secondly, my lord, they be directed to produce by way of
Okay,
additional
in
document.
7, Mr. Okay. And Mr. Talo for the respondent, staff, is requested, list this matter again on 22 July. The interim order passed earlier shall continue to. Then. No, interim is in whose favor?
In maintenance case, in our favor, my lord.
In your favor.
Payment of 8,000. per
Okay,
month.
okay. Same date, same date,
My lord, a small prayer.
What?
in you all. My lord, they have made a categorical statement before this honorable court that they are paying the maintenance. So they may be directed through an additional affidavit to furnish the reports of the transaction details of the maintenance payment.
So
Because my lord, before the learned trial court, they are not, that's why, they cannot make a statement.
see, if
They are moving application in the trial court and produce the.
My lord, if my lord will see the judgment order in 7 April,
now see, it is pending, the trial is going on.
it is stayed, my lord.
Okay, it is state.
So my lord, the issue here being that as the matter is pending here, so we are making this submission here because on 7/4/2025, a question was directed to the petitioner whether you are paying the maintenance, and on that date they made a categorical
No,
statement.
whether by this court, any direction was given?
Yes,
to
my
pay?
lord.
Where?
Yes,
By which
the
order?
first order, my lord, 22/11/2020,
22/11,
2023, my lord, the first order,
2000?
23, my lord,
No, this is item 7.
item 7, my lord. Petition 212 of 2023. my lord.
Okay. The Lani counsel for the respondent, Mr. Talo, submits that.
My lord, herein I am the petitioner.
Hmm?
Herein I am the
You are for the petitioner?
Yes, my lord.
Okay, Lani counsel for the petitioner, Mr. Talo, submits that. Although there was a direction by this court on 22/11/2023 to the respondent to continue to pay rupees 8,000 per month to the petitioner. However, the petitioner, the respondent has not paid the maintenance amount since when?
Since nearly a year, madam.
Okay.
That's why we are saying, my lord, if they paid, they may fine.
He also put on the application at the side for the statement from the officer of the Department of Police.
The respondent is not paying the amount, said amount. So the respondent is once again reminded of the direction given by this court on 22/11/2023 to continue to pay rupees 8,000 per month to the petitioner and also to pay the arrear. Continue to pay 8,000 per month, and also to pay the arrears within 3 months from today. Okay.
Much of it.
Hmm?
Item number 5.
What is to be done?
My lord.
There is a stay in that.
I'm praying today, my lord, because trial has been concluded at the court.
Now, since you are facing trial here, the other case, the criminal case,
Yes,
you are facing. So what is the point? It's all the same. Appearing, you will be loser by then. Because if we stay in that case, and if ultimately the trial is to proceed, then you may have to come again for that. It is always better to get both the case fixed in a day, one particular day, and appear in both the case. That is better for you. Otherwise, you see.
I was saying, my lord, because in this matter outside.
Because it's all the same. The witnesses accused are all the same in both the cases. No point. You will be loser otherwise. No? Okay.
Much of it.
6 disposed 5/22 July. 7/22 July. Okay.
Much of it.
Yes. Item 6. Yes, I also disposed. Yes.
Subsequently, I was called by the IO, and again I have appeared on 10/6/2025, and on that day my statement has been made. Otherwise, my lord, if your lordship may consider the other merits of the case, my lord, this is completely a case of civil nature. There is even if the allegations are accepted for the sake of argument.
On your appearance, your statement, police has recorded your statement.
Yes, sir.
Whether you were arrested,
No.
not arrested, not shown arrested.
29/4/25, I was granted interim protection by this honorable court, my lord. And thereafter pursuant to and I was directed to appear before the IO, my lord.
Okay.
And pursuant to that order, I have appeared.
Okay. So, no, sorry.
Since I have complied with the order,
He is complying with the, I think,
No, Lordship,
cooperating with the IO.
he is not revealing the truth, Lordship, as per the.
How you can compare?
The IO, Lordship, as per the.
How the IO can compel to reveal the truth? He
That
give
he-
a statement, that's all.
There may be distorting fact, Lordship. That's why.
So what? Then we cannot compel.
Yeah.
So what do you want?
The Lordship, the IO says he is not cooperating, Lordship. Only appearance in the.
He's appearing. You want him to torture inside?
Not exactly, but the.
I can additional affidavit, my lord. What happened when I appeared on 7/5/25, I was putting pressure on me that you pay the amount which is allegedly due on me as per the FIR, my lord. And if I do so, that informant is ready to withdraw the case. On first day when I appeared, IO was suggesting all this. And I was asked to stay 2 more days in there so as to confirm.
And what was your reply?
Lordship,
What was the reply of the accused to pay the amount and to withdraw? What was the reply of the accused?
no,
in that?
Lordship, if there is any amount due, I'll pay money. But for that, Lordship, they have to prove that there is any amount due to me.
Okay, according to you, no amount is due.
No, my lord.
Okay.
Lordship,
Then-
this is completely a commercial dispute, man.
What is the dispute, by the way? Just a minute. What is the, let us see the,
I have started at page number 18. I'll go to the lengthy FIR, Lordship. May I read?
yes.
From with due respect, I am informed.
Okay, come to next.
Inform you that I am proprietor of Footbakers next name guest house, putting a lodging situated at Stadium Road, Namsai, District Namsai, Arunachal Pradesh. That sir, on the month of January 23, I had approached one person namely Anupam Das, representing Akriti Interior and Exterior Solution for material supply and installation of a pergola with roof glass at the terrace of the Footbaker next guest house, Namsai, Arunachal Pradesh, and on details so on request and initiation from me, the above mentioned person, Mr. Anupam Das, on behalf of MS Akriti Interior Exterior Solution, send the quotations to me and the estimate for Kesia Bose, such as that with an estimated amount of rupees 30,000 only, the copy of the same is annexed. That's on dated so I have partly deposited rupees 25,000 to a Euro SBI and later on dated so an amount of 7,000 transferred to UBI transaction in favor of Akriti Interior Exterior Solution. I am the proprietor. The Akriti Interior and Exterior is a business partner. So the copy of the same is annexed here with as that's our on so as per the discussion between me and Anupam Das, that is the accused, representing MS Akriti Interior and Exterior Solution, has submitted your rates as per your due, along with layout from my client's mail ID address for estimate for interior work with the grand total amount of rupees 6,07,164 rupees only. The copy of the estimate and thereafter on the I am good faith and believe by the mode of bank transfer deposit an amount of 6,07,164, that is the estimated amount in favor of MS Akriti Interior and Exterior Solution maintained in ICICI Bank bearing account number so for entire 100% cost of material supply and installation of the pergola with tucking roof glass at the terrace of the Woodpecker Nest Guest House, Namsai, Arunachal Pradesh. Copy of the transaction details are annexed. That's yet again on dated so I have received a mail from Mr. Anupam Das mail ID on behalf of MS Akriti Interior and Exterior Solution reflecting the bill of tax invoice in my name stating the cost of PVC board and CNC cutting with a subtotal of rupees 32,000 and ICGST of 18% rupees 4,500, scoring a total amount of 36,000. That's as per the agreement terms. I have paid Akriti Interior and Exterior Solution the 100% cost for the material supply and charges incurred upon installations. Furthermore, I have achieved all the requirements as per the terms of agreement. Whereas Anupam Das and his firm has failed to comply with the terms and completion of work as per the schedule, which is incomplete. That's in spite of repeated positive requests and approaches from me in regard to the work taken up by Mr. Anupam Das and his firm, Akriti Exterior Solution, which is incomplete. Neither the same person named Anupam Das nor his firm and Akriti Interior has responded not take any positive steps in this regard, and it is also not understood as to why Mr. Anupam Das or his firm increase and changes for offering discussion which reflects gross negligence and default on their part despite entire payment of the above mentioned gold entrusted on and on repeated request dated so and so I have received 10,000 with a refunded 10,000 rupees from Anupam Das to Paytm. The photocopy of the transaction is annexed. Thereafter, no any response has been received from Mr. Anupam Das and Pretty Interior Exterior Solution till the month of September 23. On dated 5/23, Mr. Anupam Das had paid back me an amount of 40,000, another refund amount of white BSA POS transaction at IN Reliance Ticket Limited, so and so. And the remaining amount, here only two refund amount is mentioned. Lordship, I have annexed the bank statement where it is reflected. I have another 40,000 I have returned back. Totaling a 75,000 I have already refunded. So it continues. And the remaining amount including interest sum up to the total amount is due. The photocopy of the transaction is annexed and marked as 20. That's how I'm suffering in irreparable loss due to the act of Mr. Anupam Das and his firm negligence and incomplete work. That in spite of repeated requests from Anupam Das and his firm, Pretty Interior Exterior Solution declined to comply the same with broadly destroy my peace of mind.
Okay, you have closed the this your farm.
No, I have not closed my firm. It is
Don't defunct.
refund. According to
No,
them,
defunct.
Lordship,
Your farm company gone defunct.
no, refunded already 75,000 I have refunded, my lord.
I am saying DEFUN, defunct. Whether your company still is functioning.
Yes, still functioning.
Why you have stated?
What?
I'm sorry.
Continuing my word, there are some, I have explained in my application, my lord. Kindly, Lordship, kindly see the paragraph 5, Lordship. The actual fact I have narrated, my lord. Paragraph 5 of my application.
What it says?
The informant. The actual fact in the background of the FIR is that the informant had approached the accused petitioner farm in the name and style MS unfitting interview for the purpose of.
See, just a minute. You have appeared before the police and stated that the company is defunct. And you were in deep trouble financially. So that means the remaining amounts you are going to refund. Remaining amount. Admittedly, you did not refund entire amount, isn't it? The remaining amount you are going to refund the informant. Is it the case?
Some sort of amount may be due, Lordship.
Okay, then are you going to pay that?
I think, my.
Have you stated before the police? Have you stated before the police, or have you given in writing that this much amount according to me is due and I'm going to pay it? Have you? So then how do you think, on what basis you are saying that this is a civil nature of case? Unless you admit the part and then it's not a civil nature, because after accepting all those amounts, you see, you are nowhere to be found.
This is a case of recovery of money.
That is why I'm saying, have you admitted that I'm still due? I'm going to pay it back.
Lordship, already half of the work is done. I have annexed one photograph of the construction.
Maybe, but thereafter you remain absconding. Absconding means you were nowhere to found.
No, I'm not absconding. I was ready to complete the work, but what happened, my lord?
Have you communicated this to the informant?
Yes.
Where?
But informant was not willing to continue with the work, and she was asking to refund, asking a refund. That is the issue, my lord. I sought some time to complete the work, my lord, but she was not agree. She was asking for the refund.
Where is the?
Lordship, I'll appear, Lordship. Lordship, here, Lordship, the statement or record.
He appeared.
Yes, Lordship,
His
appeared,
statement
Lordship.
also.
Yes, Lordship. That's why, Lordship, in his appearance, Lordship, his statement is like that, Lordship, that as per the agreement, half person is completed, but Lordship, 99,000.
Where is the status?
Yes, Lordship. But 99,000, Lordship,
So we'll not go into that.
Lordship.
Before, how much amount? But if he is cooperating, That's enough.
His cooperating lordship, he has already statement is
whether
lordship.
stated-
Is here,
status
here
report-
lordship, that is statement lordship.
This is, hmm?
Yes, lordship, this next page is the statement of the accused lordship.
This is statement only.
Yes, lordship.
What I'm saying is the status of the case,
Status lordship.
progress of the investigation.
Mhm.
Heard Mr. P. Deka, Land Council for the. MM? Jaman, Land Council for the petitioner. Also heard Ms. Hill Hage, Land, Public, Land Additional Public Prosecutor. By an order dated 29/4/2025, come the accused applicant. The police says that your custodial interrogation is necessary.
The nature of the case, my lord, may kindly consider, my lord. This is a case of civil dispute, recovery of money, my lord. This is a commercial dispute, lordship. Custodial interrogation, my lord, not at all necessary, my lord. In fact, lordship, the FIR, even if accepted to be true, my lord, it will not make out any offense, my lord. And the Honorable Supreme Court has also observed in some of the authorities, lordship. And since I am complying, my lord, I am cooperating with the investigation, lordship, and I was granted entry, my lord. So at this stage,
The-
my lord, maybe we can.
The accused applicant was protected by an interim order after obtaining the interim order, the accused applicant appeared before the IO of the case. And on 10/6/2025, on which date the IO has recorded his statement. The Landed Addition PP produced a status report of the status report, and I have perused the same. The record reveals that
Lordship, that status report is lordship before the accused appear before the IO lordship. It is earlier status report, lordship.
then why you have produced the
Lordship,
status report?
Lordship,
Which is-
there's only I have lordship because this time lordship they have not sent the status report. They have sent just statement of the accused lordship. But I have
No, no,
spoken.
no, that is only after
Yes, lordship.
6. Okay. Okay, copy of the produce the case diary, and I have perused the same. Not the status report, then case diary. There are other co-accused also in this case.
Sole accused lordship.
Okay, he went with some other person there, Jyoti Burman.
Lordship, this morning I spoken to IO Lordship. He's consensus that Lordship, he's cooperating, but Lordship, if the Lordship is willing to give the Lordship indulgence on bail, a strict condition may be imposed Lordship, so that he can appear before, and because his statement is not Lordship, he can rely any
From the
document
report, it
Lordship.
appears that the accused is cooperating with the IO of the case for investigation of the IO for investigation of the case. In view of the above, this court is of the opinion that since the accused is cooperating and appearing before the IO and has also given his statement, the custodial interrogation doesn't seem required. Doesn't seem required in the present case. Stop. The present case, more particularly when. And then, okay, seems required. Huh? Stop. In view of the above and considering the nature of allegation in the against the accused, this court is of the opinion that the interim order passed on 29/4/2025 can be extended. Accordingly, the accused shall remain under the pre-arrest bail, under pre-arrest bail. Sorry, accordingly, the pre-arrest bail granted to the accused on 29/4/2025 is extended. Stop. On the following conditions. Stop. That's the following condition that in the event of the arrest of the accused in connection with the NAMSA IPS case number 55/2024, he shall be released on bail on execution of a bail bond of ₹25,000 with one surety of like amount to the satisfaction of the arresting authority. Stop. 2. That the accused applicant, the alleged accused, shall cooperate and appear before the IO of the case as and when required. Next, that he shall not hamper with the tamper with the investigation evidence of the case in any manner. Next, that the accused applicant shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case so as to dissuade him from disclosing such fact to the court or to any police officer. With the above, this AB stands disposed of.
Lordship, he may not leave the Lordship jurisdiction of this. Lordship, he is
from?
Then Lordship,
That
local bail surety may be Lordship, imposed Lordship.
this same condition, I'm repeating the same condition. Of course, small addition, because we'll not say that this will be read along with this bail application. I think that's all for the case.
Lordship. Apply.
May please, Lordship, before my brother argued on merit, Lordship, the similar matter was taken up yesterday, Lordship, the illegal arm, Lordship. Yeah. Illegal possession of arm, Lordship, yesterday matter. And your Lordship directed to produce the updated CD on tomorrow, Lordship. So this matter may be taken up tomorrow. Yes, Lordship. Same FIR, Lordship, and same case diary, same case diary.
Different accused person.
Yes, different. He was arrested, Lordship.
Okay, he was arrested.
He was arrested, but
This is for his bail.
yes,
When he was arrested?
Fourth May.
May.
Now I will be more than 40 days now. 3rd May.
Okay.
Only prima facie case matter, I also concede because arm was recovered. Because notice was sent to me and I purchased the arm from one of the fellow who was already arrested for some unlawful activity. So I was called by notice. I appeared before the police station. Then I discussed, yes, I purchased one arm from this fellow because my own understand I am a neutral person. And I was given the impression that later on this guy will give me the license. So it was only under that. So now my at the most.
Very
section-
dangerous train.
But of course, at the most section affected is under arms sec. Which is, below up to 7 years. Other sections not attractive. And when 7 years comes, law is very clear, because to arrest, even arrest a person, not only commission of the offense is not sufficient. Law is very clear on that. Because up to 7 years, the necessity has to be satisfied. Why it has to be arrested? In my case, for 40 days altogether. Repeatedly, has seen the judgment, recent this until September until also. Here also the annual effect was exercised for the offense below up to 7 years below. Unless for some rare reasons for the proposal, generally bail has to be granted. Now, I am disputing here that arms were because it was me who took the police to my house who gave them the arms. I am not disputing.
You are also connected with the members of the.
No, not at all. Not
Okay. And what about the accused? What was the name of the accused who was seeking for AV?
Oh,
Not connected with that
Lordship,
person. Okay.
his name was Karandugi, Lordship.
Okay.
Yesterday's matter, Lordship.
It is not connected with the present accused.
Lordship city,
Then
same
that-
city, but it's
Separate. I
his
think
his
that-
statement only,
he-
Lordship.
He's not a member of that organization.
No, Lordship.
It's
The
a
city
separate
says
case it
something,
appears.
Lordship.
So CD will be produced in both the case.
Yes,
Same CD. will-
same city.
Okay, then in that case tomorrow. Okay, no problem. If that is the case.
Only if it is under UAE, I understand.
But not, you are not a member
I
of.
have done anything against the sovereignty of the
Okay.
nation or something,
Okay.
anything.
Okay.
And this organized crime definition, section 111, it doesn't attract. Because for them, the requirement is very different. So only at the most answer.
Okay. So, okay, hard Mr. Rajesh. Sonar, Lani Council for the petitioner. Also Mr. Lori for the Lani PP staff, who submits that the similar matter is fixed for tomorrow. And the same, this matter may also be listed along with the similar matter. What number? Where the case study has been called for.
Lordship,
Okay, list.
PS number 72, Lordship.
Okay, 72. List it accordingly tomorrow.
Okay.
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 72.
Okay. Yes.
Here, yesterday, Your Lordship,
Yes.
I prayed for doing some necessary correction.
Correction.
Yes, however, I was directed by this court to seek instruction from my senior counsel. I have taken the instruction. I have been told to not do any correction, just let the case remain as it is. And that is
Correction
proceed.
regarding what?
correction in cost in striking of the correcting the
Striking.
yeah, striking of
The
the
name of the,
council,
see,
appellant's council.
okay, no need.
No need,
to
no
correct.
need.
Okay, see.
Let the matter be
And in that
proceed
case,
without
what
any
you have to
correction.
give a
Yes,
notice.
yes.
So what, then what to do?
Next date is fixed on 27th June. Let it remain as it is. 27th June.
37 June.
Yes, yes.
Okay. Mr. M. Kambo, Land Council for the appellant submits that since the matter is fixed on 27 June,
Yes.
27 June.
which case is fixed?
This case only.
This case?
Yes, sir.
Where is the order?
Your Lordship, this case was earlier listed, and then however in
Yes,
meantime.
yes, 27 June only.
Yes,
Okay.
yes, Your Lordship.
Since this, okay, submits that since this case is directed, is fixed on 27th, fixed for 27 June 2025. Let this matter be listed accordingly on 27 June 2025. Okay.
Okay, right.
Respondent, you have received a copy?
Yes. This is the copy of IA only.
IA only?
Yes.
And what about this is IA is for what?
Yes, Lordship. This IA is for Lordship continuation of delay,
How many days?
354 days.
You have objection,
Yes, I have a serious objection. For that, I need to file an objection.
which is
Yes.
it's a second appeal. Okay. You are appearing for the first time?
Yes, it's the first
Okay.
time.
Mr.
S-N-T.
Yes,
T.
spelling?
E-N-G-T-I.
Okay. Ingti. Sivam Ingti. This is different name. Land Council for the applicant. Mr. R. Ingo. Land Council could appear on behalf of the respondent number. For
All respondents.
for all the respondents. And some state he wants to and wants to file objection for which he needs he requires how much time?
2 weeks. 2 weeks.
2 weeks. Stop. And prays accordingly. So the prayer is allowed. List is matter after 2 weeks. Okay.
Reply. Much obliged.
Yeah, Lordship.
Yes.
Lordship, item number 12, IA. This is an appeal against the judgment and order dated from the CGM TU where my case has been dismissed. Lordship, the IA is for seeking leave of this honorable court to allow me to appeal, to file an appeal, Lordship.
To file?
An appeal, Lordship. Under section 419, Lordship, it says whenever a appeal is filed before a high court, a leave has to be seen from.
Normally, okay, this is the.
This can be, Lordship, disposed of today if a leave is granted, Lordship.
Okay. Mr. Bijabo, Land Council for the applicant. By filing this application, the applicant seek leave of this court to file appeal against the impugned judgment in order dated 24/3/2025 passed by the Land Court of Chief Judicial Magistrate Lohit in complaint case number 02 within bracket L bracket close capital L stroke 2021 under section 138 INI Act staff. The prayer considered and allowed. The applicant is allowed to file appeal accordingly. Stop. with the above these higher stands allowed and disposal.
Yes, Lordship.
Okay, and then appeal
And
already
Lordship,
registered.
not yet, it's registered, Lordship. The other IA is for, there's a delay, Lordship, of 16 days. The other IA
Other IA 4.
is for,
This is IA 49, huh?
Yeah.
And this is IA
48.
48.
Yes.
48 is for what?
For Sir, Lordship, there's a delay of 16 days in filing this appeal.
Okay,
So,
then
in this
we'll
moment,
issue notice here.
yes, Lordship.
Mr. Jammu, Plan Council for the applicant, stop para. This is an application filed under section 5 of the Limitation Act, the Indian Limitation Act. Limitation Act 1963 for condoning the delay of 15 days in filing the connected appeal. Stop, issue notice. The applicant shall take steps upon the respondent. How many respondents?
Lordship, this is one respondent. This is a
Okay,
private complaint.
respondent
Lordship.
by a registered post with AE within as well as by usual process.
Yes,
within a
Lordship.
week from today. Start. List this matter after 4 weeks.
3 weeks, Lordship.
3 weeks. Okay.
Deeply obliged. Lordship, item number 13 is also the analogous matter. Only the party is different, Lordship.
Okay.
Same
Then
order.
which one is for leave?
The leave is for item number.
IA 50 is for leave.
Yes, Lordship.
50 would be same disposal order. Okay. And no, 50 is okay. Disposal same. Okay. Only the number difference same, huh? And then the impugn order also same.
Yes,
Same. Okay. And then in IA number 75 notice.
51, Lordship. Item.
Oh, sorry,
I-
51.
yes,
51 would be same notice.
Yes, Lord.
Okay. This is for condonation of delay of how many days?
Same for 16 days, Lordship.
Same days.
Same day.
Okay. The delay of condonation of delay of how many days you say?
So it's
15 days.
15 days. Lord.
There also.
Yes, Lordship.
Delay of 15 days. Okay. Yes.
Deeply obliged.
Lordship, this IA for condonation of delay of 61 days in filing MSc appeal.
Make appeal.
Yes.
Okay. So
I'm on the behalf of respondent Boluram Das.
4 is 4. You have objection?
Lordship, we have already filed the return statement.
What?
Yeah.
You
You
filed
filed the
objection?
affidavit.
Yes. Already filed.
Your Honor, I have an objection to their
How many days?
61 days.
61 days.
Yes. Lordship, here I'm for the insurance company and
What about the, you are for
the
the claimant?
insurance company.
You are for insurance company?
Yes, I'm the appellant, yes.
And you are for?
For the
Claimant.
claimant. I think.
Claimant. Why the claimant should have an objection?
Lordship, I was just instructed by the leading counsel, senior Boluram Das.
You are for HDFC,
Yes.
Ergo General, okay. Versus Rinching Chaudhary. Rinching Chaudhary is a claimant. And you, your basic question is raised in the appeal is regarding what?
Lordship, that we are not liable to pay compensation.
You are not liable to pay.
Yes.
Why?
Lordship, they are the occupants of the vehicle.
The okay,
The vehicle
victims are
that met with
occupants.
an accident.
So the scheme of the insurance doesn't cover.
Yes, Lordship.
So whether, have you made the owner also the party? Then,
Lordship, here the owner is succumbed to his,
then who is liable?
the owner was the driver.
Owner was driver, and
Yes.
whether you have met owner and the driver as a respondent party?
Your Honor, the owner and the driver is succumbed to the injuries in the accident. And he
Okay.
has no legal representative also.
The driver was the owner,
Yes,
and he is no more.
yes.
So according
So-
to you, who is liable? Who is liable?
Lordship, actually, it should be the owner,
Yes. Then owner has a legal heir,
no legal heir.
no legal heir.
Yes.
What in the trial court, whether you have made party to the no legal heir in the trial?
No
court?
legal heir was there, no one was there.
Then who claimed that?
Lordship, the co-passengers who sustained injury. There were 5 passengers in the vehicle.
Okay, the claim petition was filed by the
Passengers.
passengers.
Yes.
So the claim co-passenger did not make any, the owner doesn't have the legal heirs.
No.
How is it possible? How it is possible? The owner doesn't have a legal heir. He doesn't come from the sky. Must have had the
Your Honor,
legal
that-
heirs.
that claimant should have included them if there was any legal
Hmm.
heir.
Because if the owner is liable, although he is no more, but then
Yes.
his property would be there if he is liable,
Yes.
and his legal heir has to pay. No, or what?
His Lordship, but the problem is that he has got no legal heir.
Then in that case, they will insist on the condonation of delay. You have to prove it properly then. Okay, Mr. G. Kato, land counsel for the applicant, insurance company, stuff. Also heard. Miss, you are who? Your name is not there?
Yeah, in affidavit, my name is not reflect, but
Okay. Otherwise, you
was-
have also signed the affidavit, wakalatnama.
Yes.
Okay, Dirilo. For land counsel appearing on behalf of the respondent claimant, staff of para. This is an application filed under section 5 of the Limitation Act 1963 for condonation of delay of 61 days in filing the connected appeal. Against the judgment and award dated 16/10/2024 passed by the learned member Motor Accident Claims Tribunal, East coming. Where is this? Bomdila
Yes.
Tribunal, Bomdila. In MSC case, MSCT case number 13/2022. The ground for delay in preferring the connected appeal has been stated in para. Which para?
Lordship,
Where is the ground for delay? Where have you explained the ground for delay? In
Lordship
which
is-
paragraph?
para 6.
In para 6.
Yes.
Of the application. Where is it? There is no explanation in para 6, huh? Para 6.
Yes. Your Honor, we've stated
Private sector general insurance company limited is required to act strictly as per laid down procedure, and as such, the files are required to be routed from one office to another, from its branch office at Guwahati to, that is from its branch office at Guwahati to the main office at Mumbai, and again from Mumbai to Guwahati. And thereafter to the councils. And in the process, there has been a delay of 61 days. In preferring the connected appeal. And that connected appeal staff, it is submitted that the delay, if any, was neither intentional nor deliberate. Staff. The respondent claimant raised objection by filing affidavit in opposition, stating that the day-to-day delay has not properly been explained. Stop. Having heard the Land Council for the parties, and on consideration of the explanation given in the given in the delay petition, the condonation petition, from this court is of the opinion that the petitioner was prevented by a sufficient cause for not preferring the connected appeal within the stipulated time. Stop. In view of the above, this in view of the above, the delay of 61 days in preferring the connected appeal is hereby condoned. Stop. With the above, this I will stands allowed and disposed of. Where is the main? Main has been numbered, already numbered, or what?
Number 14, 15. 14, 15, and 16.
Is there any stay petition? No.
no.
Okay. In the appeal, no? Appeal is filed. Okay. Had Mr. G. Kato, Land Council for the appellant. Also had Mr. Okay, not also had staff. Huh? This is an appeal filed under section 173 of the Motor Vehicle Act 1988 against the judgment and award dated 16/10/2024 passed by Motor Vehicle okay, judgment and award dated so and so passed by the member Motor Accident Claims Tribunal, Bomdila, in MACT case number 17/2022. Stop. Huh? The appeal is admitted Para. Call for the relevant records. Para. Issue notice. Para. Since Miss Dirilo.
Rilung, RLLUNG.
Landed Council appear and accepts notice on behalf of the sole respondent claimant. No formal notice need be issued to the respondent's staff. List this matter. Since the parties are you want to file any objection? You want to file anything? No. List this matter. List this matter after 4 weeks. Okay.
Item number 15.
Your 14, 15, 16 are
14, 15
connected
and
cases.
16. Lordship.
14, 15, 16.
Yes, Lordship.
Okay, then IA dispose of same. Okay. IA number will be different. And then the name of the part different. Dates are the delay are same.
Yes.
61 days.
Yes.
Okay. 15 similar order. And then 16 also similar order. In all. IA same and on the main same. Okay.
Progress.
All IA disposed, 3 IA disposed, and then in all, after 4 weeks. Yes. Yes. Also put a petition not come up to the. Also, this is filed by the council. Petitioner is not present. Yes, no, sir. Then, who is the counsel for the petitioner? Your man, is there any stay? On the next date? You mean petition for what?
Lordship, crossing
What in the
crossing
crossing petition? Why
crossing of FIR, but
crossing of
in
he was
the
directed to
meantime,
appear before the eye of the case also here.
in the meantime, the accusers are seated, Lordship. So T-shirt called for.
Okay, the record was called for thereafter.
Yes, Lordship. And
Okay, whether you have you received the record?
TC is there, Lordship. Since we have no access over the TCR, Lordship. TCR called by the registry only, Lordship.
Okay, thereafter. Because the chart seated already and the
Yes.
record called for. CGM UPR. This was in the last order. None appears on behalf of the petitioner, while petitioner while Mr. Ridoy, Lana people. He is present on behalf of the state respondent staff. Record received.
Yes, Lordship. Okay. TCR is there, Lordship.
So it's a scan copy only.
Yes, Lordship.
Okay, no problem then. Why this? Okay. What is this matter? What he was supposed to be present online.
Yes,
What is
sir.
this matter about? Otherwise,
Lordship, in fact, this matter was endorsed to the Getty Tado Lordship. It isn't popular. He is not turn up today. I'm also not aware with the fact. Lordship,
Lordship, this is regarding some payment lordship. There's some due payment lordship. The Honorable Lordship is JMFC court also granted bail lordship, the accused lordship. There the condition was 2 years lordship. Condition was that the remaining amount should be paid lordship, and it is in the reflected order that.
let us wait for some time then.
Yes,
Let
lordship.
him be present. Okay.
It may be fixed another date lordship today.
None appears on behalf of the petition while land council for the state respondent. Land council, land addition people for the state respondent. Only the state is the respondent here.
Yes, lordship. Only one private respondent also there.
Okay, no.
Respondent number 2 lordship, yes. He's
In
also
absence of
absent
the-
today, yes.
In absence of any representation from the petitioner, the matter stand adjourned. List this matter after 3 weeks.
Lordship. Obliged.
Finish.